Welcome to FranchiseWire Live. I'm your host, Red Boswell, president of the International Franchise Professionals Group, IFPG. We're joined today by another great leader in franchising, Miss Nancy Lanard. Nancy is the founder of, well, she's a franchise attorney, but there's an extra E on that. She is a franchisee attorney. Nancy, welcome to the call today.
Thank you so much, Red. I'm excited to be here.
Well, honored to have you. Been trying to get on us together for a while now. Nancy, you are in Philadelphia area, and boy, y'all had some pretty crazy storms. You all good now?
We did. Actually, the sun is out. The sky is blue. It's like nothing ever happened. Most of the ponding around the area is dried up. It's amazing, but there was some serious flooding. We had that tropical storm that came through this morning. So
Yes.
It's all past. It's all good.
Well, glad to hear it. My office is, I'm in Dallas, Texas, but most of my team is in North Central New Jersey, and boy, they got no electricity. Phones aren't working. It's they've missed some calls, and they can't even they're trying to reach folks. It's been tough, but thanks for being on here.
Yes.
So we're here to talk. The message is typically for ZORs, franchisors in the industry, but really any business owner and certainly franchisees as well could benefit. And you are an expert. You're an attorney, been in franchising a long time, have a great team, and it's interesting too that you represent franchisees. So, you're not a ZOR. I'm used to interviewing ZORs for the most part. So let's just talk about first, help us understand who you and your firm are, and then we'll talk about what's happening in the world of franchising, from real estate to the future of legal issues to item 19s and what those look like. We're going to hit it all today.
Sounds perfect. I love it.
Awesome.
So my firm consists of, we are 6 attorneys. All we do is represent individuals looking to evaluate a franchise, and often are actually referred by not only franchise consultants at IFPG and others, but also by franchisors, because they know that we do a good job, that we don't break deals, we turn it over quickly, and we charge a flat fee that hasn't changed in over 12 years. So and we know what we're doing. This is what we do day in and day out. So we evaluate the franchise documents. I make it very clear, if it's an established franchise, it's extraordinarily unlikely that it's going to be a negotiable document at all, that the purpose of this exercise in retaining us is for education purposes, to understand what this lengthy document, both in size but also in the time frame that it will be, is an important document that they need to understand. We've represented even attorneys over the years, as well as franchise consultants who are looking to invest in a franchise opportunity for themselves or for a family member. So that's been something. I was in-house counsel to Nutrisystem 25 plus years ago. Nutrisystem at that time was the #1 weight loss company in the United States, with 1,300 franchise locations and 500 corporate. So I've been on the franchisor side. And when I started my own law firm, which is when they went into bankruptcy, I was handling both franchisor and franchisee legal matters. And I made the conscious decision for my firm about 3 or 4 years ago that our practice was going to be exclusively franchisee side. And the reason for that is that way, any consultant, anyone sending work our way, referring to us, knows that we never have a conflict. And I think that's an important thing, because so many other firms represent both sides, and I think they find often enough that they have a conflict of interest in representing one side or the other in the future. And so we made the decision. We felt this was a very underserved area, actually, to just handle transactional. We don't go into court, we're not litigators, so we never suing franchisors, we don't handle any disputes of that sort. And so it's a very niche area of law.
It certainly is, but a needed and high demand area. So let's first hit a hot topic: real estate. Now, I'm hearing all sorts of things. Some landlords aren't negotiating, while others are desperate. How are you represent the Z's, so what are you seeing out there from a Z standpoint?
Yeah, it's a really good question. So that is another area that's a major focus area of the practice, is in addition to evaluating the franchise documents, we will set up their entity for them if they're not using ROBS for that, and then we'll handle the lease if it's brick and mortar. And yes, it's been a very challenging time. And unfortunately, I think franchisees, as truly the epitome of a small business in this country, is hurt more than almost anybody else. And it's been a shame. Back in March, when things first shut down, I spent literally day after day after day looking at clients who I had represented for their lease, looking at their leases to see what kind of help we could provide. And I did 30 leases in one day without literally charging anybody anything. And I did that for 3 weeks, where I just was looking at clients' leases to help them out. And I will tell you,
when you say you did 30 leases, what does that mean?
Oh, good question. I'm sorry, I did kind of skip over that. I looked at to see that if there were provisions in each of those leases that we had already worked on that would help them with relief from rent during a closure, whether it was the force majeure, which is also called acts of God clause, or some other area of the lease that they could rely upon and go back to the landlord and argue that they were not obligated to pay rent during that time. I also was on several different advisory boards to several different major franchise brands around the country that had 500 to 1,000 franchisees around the country, and helped them with strategizing for helping their franchisees. These were all brick and mortar brands. So it is definitely an issue. Unfortunately, in the traditional force majeure act of God clause that is in, the standard lease, we've always softened it with provisions and broadened it, but we of course never contemplated COVID-19 type of pandemic, right? Who did? Right. So we never really focused on that. But in early March, we started being very proactive, actually before the shutdown started, and adding to all new leases we were working on a COVID-19 specific force majeure clause that allowed for rent abatement or rent deferral during a government shutdown or during a pandemic. As far as leases that happened before that, unfortunately, in most cases, the landlords, there was nothing in there. It always excluded rent from any kind of force majeure, no matter what. You could be in the middle of a hurricane, you could be in the middle of a tornado, it doesn't matter. And we also did a bunch of articles. I did a lot of blog posts that I sent out, newsletters on business interruption insurance, which is another major issue.
You read my mind. So you actually reviewed insurance agreements as well.
Well, we don't normally, but I was giving advice as far as what to do. And because the reality is that these insurance companies were denying every single claim. And we know, I know that from everything I've read, that not only do I believe there might be legislation that will remedy that someday, hopefully down the road, to provide for legislative relief that small businesses can have for business who had business interruption policies. But also, I think there's going to be a tremendous, and there already is starting to be a tremendous amount of lawsuits against insurance companies making claims that they should be paying those business interruption claims. So my advice to my clients was, regardless of the agent, the local agent telling you no, you need to push this to the point that the company itself rejects it, and then hold on to that, because at some point there's going to be class action lawsuits against these major carriers, and hopefully you will preserve your rights by doing that. So that's a very important topic, I think, right now. Is I'm not an insurance expert, that's not my area of expertise, but I think I always have recommended, really for the last 30 years, that people have business interruption insurance to cover acts of God kinds of things happening. And here we had the ultimate, and yet these companies are rejecting it because they're saying a virus isn't covered, or closures that are mandated by the government are not covered. So it's unfortunate, and I think wrong in so many ways.
We had recently, you're so right, we had a gentleman who had an expertise in that specific area, and insurance agreements, and he went over so many different cases where it may say you're not covered here, but if they forget to say you're not covered there later on in the agreement, different section, but they're required to say it in both places, or maybe 8 places. If they miss one single place of including that as not covered, it's covered. And so that was fascinating for a lot of Z's and Zors who went back and had someone else look at the agreement. Sure enough, boom, got covered.
Yeah. There are law firms that's their specialty, is handling insurance rejections and insurance claims. And I think this is a huge area right now that's going to be a very big area of conversation that needs to be addressed. I don't know if the IFA Legal Symposium is coming up in this month, and I think it's this month, and
virtually.
Virtually, yeah. Well, so is our ABA meeting in October, is virtual even. But the IFA Legal was supposed to be May 3rd, I think. And so now it's been pushed back, and I think it's this month, but virtually. And it would be a great topic to have as a conversation, to be talking about it at the IFA Legal.
Well, no doubt another big topic you'll be talking about is what are we doing with item 19s and how that's getting covered, and maybe a mid-year update. Any thoughts or perhaps suggestions for ZORs in that arena?
I'm not the franchisor side per se, I'm the franchisee side. So from the franchisee side, looking at an item 19, there were new guidelines that came out for item 19 disclosures by NASA a few years back. And I think it's very important that every, franchisor certainly comply with them. I think it's not the easiest to interpret. And so I think, having strong guidance from good franchise counsel that represents them is important. I think, unfortunately, not everybody is as candid and straightforward and honest in their item 19. And as an attorney representing franchisees, we don't handle any litigation or disputes, but as an attorney that represents franchisees looking at an FDD, I'm always a little wary of an item 19. It's not something I tend to really have much of a discussion with my clients about, because it's not something that I personally put a lot of weight on. I think far more important to validating a franchise system. Look, everybody looking to buy into a business opportunity of any sort is going to want to know how much money they can make. And so I understand the value of an item 19 to a franchisor. I think it makes total sense. And I think the franchisor that doesn't have an item 19 disclosure is at a disadvantage to any competition that they have. However, from a franchisee perspective, I think that it has to be taken with a grain of salt. There's nobody out there auditing it. There's nobody out there. The examiners aren't, even in the states that have registrations, the examiners aren't auditing it. So how do we know that it's accurate? How do we know that I can tell you that I have had people come back to me a year or two later and tell me that they were completely false, the item 19. And of course, as I said, I don't handle disputes, so I've referred them to other people, other attorneys. But that's problematic. That creates an issue for me as an attorney representing and trying to help franchisees. So I think the important thing that I can tell franchisors is please make sure you're doing it correctly, that you're accurate, that you're not misleading in those numbers, that you are being completely honest and straightforward in them. Because if you're not, chances are at some point you have a disgruntled franchisee who's going to figure it out.
You will go down hard.
You will, and that's unfortunate.
Yeah, and I think it's pretty rare. But if anything of substance, they've got to be auditable, not audit head, but auditable. And if they're not, boy, you're going to have an upset franchisee, and you're going to have somebody call you out on it, and you will go down hard. So
go down. Yeah.
Good advice.
And actually, the same is true with item 7. If you don't have the item 7 stated correctly, I can tell you that's going to be another area where people are going to sue you, because I remember a brand, and I won't, of course, say their name, but several years ago, that was a very hot brand. And I was told by multiple clients of mine 6 months, 9 months later, once they had done their build out and had gotten open, that their item 7 that it cost them 3 times what the maximum was in the item 7. Well, who budgets for that?
Wow.
Right.
That's rescission like that,
Yeah. Well, it's not if you're in a state like Texas or Pennsylvania or New Jersey, where there really isn't a franchise law that's going to protect you from that. So
would federal law not protect you from what would you call that?
Federal law doesn't have enforcement. They have people to enforce against franchisors for failure to comply with providing FDDs and those kinds of things. But it's really the states that are registration states that really have the ability to require rescission and those kinds of things. In a state like that, like Texas or Pennsylvania or New Jersey, to give a few examples that we just talked about, those states, it would be breach of contract, basically, and misrepresentation,
fraud
in the inducement, those kinds of things. Yeah.
We're getting deep here. Like it. All right. So Nancy, what you are that you're such a cool niche focusing on Z's. What can you tell the Zors out there? Hey, Zors, we've covered a little bit already, but hey, Zors, here's where I see Zors messing up, or here's where Zors need to be looking in the near future because this is coming, or this is happening, or this is a trend. Any advice for Zors?
Well, I mean, I think we just went over two areas, item 7 and item 19. But I think, never discourage your development people from, encouraging franchisees or prospective franchisees to talk to anybody that's on the list that's in the FDD of franchisees and former franchisees. And I can tell you that many franchisors do try to discourage that and push the prospects to talk to only those people that they connect them with. And of course, it's human nature for anyone to only want to connect you with people that are happy campers in your system, right? And so I'm there on my initial free consultation with a client saying, you need to call from the list that's in the FDD because you don't know that those aren't people that are just handpicked because they're excellent, franchisees that are making a lot of money and at the top of the echelon. You need to talk to anybody that's on that list. It's your right under federal law. So that's one thing I would say is that they shouldn't be afraid of that. If they're a good, solid system, they should be encouraging their prospective franchisees to call anybody that's listed in that FDD.
Amen and amen. Now, I'll throw the caveat. As a Zor, I would always, requires a harsh word, but I would inform my candidates, you can speak with anybody. We encourage you to speak with anybody, rah, rah, rah. Let me know who you would like to speak with, and I will make that personal introduction for you. That way the Z is not surprised because we've trained our Zs to turn away and not speak with anybody that has not been introduced, because you're going to get a lot of folks try to skirt the system. They got hold of the FDD somewhere free online, or maybe they had one call and got the FDD and they're not calling at the right time. They're not qualified. They're not approved. And so there's a balance there. Talk to anybody, but let me know who you want to talk to and I'll make the introduction. That will validate you and allow them, or allow is not the right word, but you'll get through.
And that's a sign of a good franchisor. Honestly, yeah. You're not afraid. Right? You're not afraid. I mean, I think that a good franchisor is someone who, a company that actually is there to find good candidates, that wants good candidates that are there vetting their system because they aren't afraid of what will be uncovered if you look under the rocks, and helps with all of the transition, including educating on what's in the FDD. I mean, I'm amazed that I hear from consultants who say, oh, you don't need to hire a lawyer to review this with you. It's not negotiable anyway. Why would you need to have a lawyer go through it? And you don't really even need to read the FDD. It's just a lot of boilerplate, a lot of whatever. Exactly my reaction, Red. It's like my eyes pop out when I hear that.
That is not an IFPG consultant.
No.
I pray.
And I'm not naming who they are, but you and I both know that there are consultants that are in the midst right now of litigation because of stupid things that they said or didn't say.
That's right.
One of which being that they didn't recommend. And my word to consultants that might be listening to this is that every consultant, every time, should be referring to a franchise attorney, hopefully a franchisee attorney, for the review, because it protects them. And it does protect them, because just having an email introduction, I keep it forever in my system. I have 63,000, I just looked down here, almost 64,000 emails in my inbox right now, all of which are read, basically, except the new ones that have come in since we've spoken. But yes, 64,000, I don't erase them. And so it protects them if they ever were in litigation, that they can say, I introduced, Joe Smith to Nancy Lanard, and Joe chose not to even call her, or Joe chose not to hire her. But at least I recommended that. I'm not the last one to have touched the opportunity with them. So if it goes south, don't blame me. I told them to go find a lawyer to go through it. From a franchisor side, I think it's really valuable for a franchisor to go through those 23 items and explain what's in there from their perspective. And then, of course, that's also what we do, and we go through the franchise agreement and explain that as well. But I think that that's a really value-added thing that a franchisor should be doing, which is describing what's in the FDD and helping, because it's overwhelming. I mean, you know, 300-page document is just overwhelming to everybody looking at it.
I tell you what, something I did, this is just a side rabbit trail here, but as a ZOR and a pretty significant pipeline of franchise candidates, tell you what, most Fran Dev folks, myself, king of the sinners here, can't stand an hour or two conversation on the FDD. You know, it's absolutely critical. If you're not doing it, you're not doing your job. At the same time, ain't no fun. So what I did, I'm a Texan. What I did was I recorded myself going through it thoroughly, step by step, explaining everything. I put it on behind a login, and that candidate was required. One of the steps was the FDD step, and they were required to log in. I had a record that they logged in. This is just little, best practices for the friend devers out there, and it accomplished a very thorough overview. I made sure they went through it because they had to log in to do so, and it saved me a whole lot of time and hassle. So anyway, I diverted the conversation.
I think that's a great idea. You didn't have to do it one-on-one. There's no reason why, if you did a thorough review of each of the items of the FDD, that it can't be a document, a video, whatever, that is canned for all, future franchisees. I think that's perfect.
And you re-record it once a year or twice a year if you update it mid-year. So yeah. Okay. What other ideas or suggestions are you seeing out there for the ZORs? Throwing you on the spot here.
I know. Well, I think slow down, honestly, from a franchisee perspective, because I think super aggressive development, and every franchisor wants to grow and be, the next McDonald's around the country. They want to have thousands or at least hundreds overnight. And I think what happens is when you do that, that you somehow dilute the system a little bit. I think you aren't able to support your franchisees the way you are able to support the first 15 or 20 that come on board, hopefully. And I think it causes issues down the road. I think it causes a lot of issues, actually. So I think you have to be very careful in how quickly you're growing and you're demanding your franchisees to develop. One of the issues with any area development that I see almost invariably is that it's too rapid. So as I said, we do a tremendous amount of commercial leases. So I know that it can take how much time? You tell me, Red, how much time does it take to even find the right location? 3 months, 6 months? And then at that point, you're working with a realtor who's going to negotiate the business terms. And then hopefully you're working with a good attorney like my firm to negotiate all the legal terms. And that's going to take time. And then you need to get permits, and you need to do the build out, and then you need to get to the opening. And really from the moment you found that location till the opening is a 6-month period of time when all things go easily and smoothly. We are living in a world today that nothing's going smoothly and easily. So if we don't learn from this, that, Murphy's Law is around big, it's a strong thing going on right now, that what could go wrong is going to go wrong. So if you figure that it could take 3 to 6 months to find a location and a good 6 months to open from finding it, you need at least a year. And that's cutting it very close.
Tell you what, do you know how many ZORs are sitting here going, yeah, that's the last problem I have, too rapid of a growth. There's a lot of ZORs wishing, praying for the second franchise being sold this year. So,
well, that's true with the new ones. I totally get that. It's struggle. That first 5 franchisees is always a struggle. But just understand that in your development agreement, when you have a development agreement out there, requiring the second, third, fourth, fifth location be every 9 months, or I've even seen 6 months, is completely unrealistic. You're just opening it up for franchisees to fail, and it's not right.
Well, so devil's advocate would say you don't have to sell one, get it open, then sell another. I mean, they can go sell one every month and have them 9 months.
But I'm not referring to, okay, so we're talking two different things.
Oh.
I'm not referring to selling to franchisees around the country at the same time. Of course you can do that. I'm saying where you're talking about a franchisee who's also an area developer, who is required under the area development agreement to develop, 10 units
themselves
in a matter of 3 years or 5 years, that's ludicrous. And that's just opening up failure, an opportunity for failure. That's what I was referring to.
Amen. I had about 10 years ago, I go into this this hot pizza concept franchise that was exploding across the country and has had quite a few issues since. And it's in retrospect very obvious why. I'm behind the counter, the lady, I'm talking to her, and I said, "Oh, are you the franchisee?" And she goes, "Yeah, I'm the area developer too." And it's like, "Oh, great. What's your development plan?" She goes, I'm opening up 42 new locations in the Dallas-Fort Worth area in the next 18 months. In the next 18 months. I was like, 42? Hey, what? I was a little green on the restaurant opening plan in franchising back then, but I was like, that is one heck of an aggressive growth stretch. And of course, she's
if
no
that's
longer
an area development or an area rep, because let's talk about terminology for a second because people get them confused. So an area rep is someone who's selling franchises on behalf of the franchisor. And if that's what she's trying to do, 42, even then it's very aggressive, obviously, to even sell 42 units. Yeah. But if she's talking about her own development, first of all, to commit to 42 units, who does that?
Yeah, right. She claimed it was all their own units, but there's probably a mix of the both. And boy, that you're right. Area developer, area rep, master, right. Those terms get so intertwined, and it's hard. There's no official legal definition, I think, between them, and oftentimes, at least in most states.
Well, there is under federal law. There are differences. So a master franchise, think of as a sub-franchisor. Yeah. They actually are in place of the franchisor. It's used more internationally than it is nationally. Dunkin' Donuts. Dairy Queen had done it in the US for a while, and they found that a lot of their franchisees, they lost control over their local franchisees, and they found a lot of franchisees diluted their formulas and so forth. So they stopped it, but master franchising is just that. Think of them as sub-franchisors, selling franchises, supporting them, training them, taking the money in, signing a contract, and they have to have their own FDD with their sub-franchisees. An area rep is somebody that's selling on behalf of a franchisor, but that's it. They're selling on behalf of. They're similar to the franchise developer or the franchise consultant. They're acting as a sales force for the franchisor, and they get a fee for that, or a percentage for that, similar to a franchise consultant or similar to anybody else that's selling on behalf. And then there's the area developer who's developing the units themselves. So
and then there's the regional developer and regional rep.
Yep, exactly.
And then there's international, which I did plenty of masters international as well, and the overlap of terms gets a little complicated sometimes.
It does.
But here we go again, chasing that rabbit trail. Love it. When we franchise, geeks get together, you can't stop us.
I know. Well, it's so much fun. We speak the same language.
And we argue over definitions sometimes. And lesson learned: don't argue a definition with an attorney. They know. What else? Anything else we share, Nancy? The floor is wide open. Anything else before we wrap up?
I would like to go back because I think it's such an underrated area to talk about again with the commercial leases, if I may. And I think that's really important for franchisors to understand that it's really a critical document. And from their perspective, I know that a franchisor is concerned. Sorry, weather issues. The franchisor is concerned with making sure that their requirements are in the lease. And of course, that's something that we always make sure of as well. But more important to me and to a franchisor, I think, should be that that the lease itself is something that's going to help the franchisee be successful. And down the road, be able to sell the business if need be or wanted to be, for whatever reason, to another franchisee. and that other party coming in can take over a lease that's a strong lease. And so leases are very critical. There are so many things in a lease that are negotiable. Pretty much the entire document is a negotiable document, heavily redlined. And it's important to have clauses in there that protect that franchisee/tenant. I did recently, actually it's almost 2 years ago now, for the American Bar Association franchise group. It's called the Forum on Franchising. I did an article that was published in our franchise journal called The Franchise Lawyer. And it was specifically on leases and the 10 most important, it was written for other lawyers, other franchise lawyers, and the 10 most important issues in a commercial lease from a tenant's perspective, tenant/franchisee's perspective. It's a really important document, and it can really influence the bottom line that royalties are paid from. So
where would we
impact
find that
the
document? Is that document on your website?
It is. There is a link. If you go to my website, which is lanardandassociates.com, www.lanardandassociates.com, that's all A's in my name. If you go to that and then click on Nancy in the media, there's a bunch of podcasts, there's articles, and one of them is that. But I will say that one of the important things in a commercial lease that I think is overlooked is that even something as simple, there's a bigger one that I was getting at, but even something as simple as having a representation and warranty from the landlord for Americans with Disability Act compliance. Somebody's coming to your site in a wheelchair and they can't get up the curb of the shopping center to get to your place. They're going to sue you. They're going to sue everybody in sight because they can't get up and the curb cut's too sharp or whatever, it's too angled. Or the doorway isn't wide enough to be able to get in with the wheelchair. Or you don't have a hazardous substances warranty from the landlord. And you know, all of a sudden the shopping center is part of a Superfund site for hazardous substances on the ground. You're going to be thrown into that without that. And that could be a lot of money, tens of thousands of dollars. There's just so much in a lease that people don't realize the critical nature of it. You know, that it's an important document. And I think franchisors really don't see the importance of it. Those franchise systems that we work with understand the importance of it. We have a lot of systems that we work with, and I think that they understand why it's valuable, why it's important, and you know, in return for their utilizing our firm for their franchisees and recommending us, we always offer a discounted flat fee to their franchisees. So it's a real win-win for everybody. But it's such a critical document. I was thinking of another clause that I wanted to mention, and now, of course, it went straight up my mind.
As you think about that, I mean, this is why people buy a franchise. They buy it for all these things you don't think about. The ZOR, right. That's their job. Think about it. Figure out the gotchas and the glitches. And the ZOR can't think of everything either, so they hire, I'm pointing at you, experts to do that for their Zs. We would hire, you know, we negotiated national contracts as a ZOR with Nissan to get better deals on trucks and the right trucks, and then something to affix onto the truck. We had that all, and that's just common sense in franchising. You bring on the experts to help with the things that even you, the ZOR, aren't an expert on. All right, did you think about what you were?
Well, I did think, so thank you. So, you know, another area is that if they're in a shopping center or in a mall or something where it's that type of shared space with common areas, they're going to be signing, the franchisee/tenant's going to be signing what's called a Triple Net Lease, meaning that it's landlord's expenses for the taxes, insurance, and operating expenses, those are the three nets, are passed through to all the tenants on a prorated basis based on square footage. And so, and that's called additional rent, or in some instances it's called a CAM charge, which stands for Common Area Maintenance Charge. And what is included in the operating expenses of that shopping center that are passed through to the tenant is a gray area. We have an exhibit to every lease that we review and negotiate of 28 items to exclude from those charges. And that can save a tenant on his or her bottom line every single month. And that means there's more revenues to go pay royalties with.
Amen. Yes.
So again, that's just another example of many. And one other thing that we also do with those charges, so the landlord's passing through the expenses for taxes, insurance, and operating expenses. And you've worked out what can be included and not included. Even taxes, by the way, we negotiate what can be included and not included, because certainly we don't want to be paying landlords taxes on the rents they're receiving. That's not right. So
have you seen that really?
Oh my God, yeah, you're laughing, but it's real, absolutely real. And
if I'm ever a landlord, I got to add that into the club. that would, people think of the craziest ways to take advantage in a very ugly way of others. I was joking, I would never do that.
They do. If you don't exclude it, you could be paying also for the landlord's own agents or employees coming out and doing damage to the shopping center. And that could be passed through as part of the operating expenses. Well, you have an angry employee who just decides to take a baseball bat and break all the windows, or, somehow do some damage to the roof or anything else, and you're paying for that. Why would you pay for that? That's not your responsibility.
Wow. I bet there's a landlord out there saying my new Mercedes is a business expense. I'm passing it through. I mean,
well, so that goes to my other point that I was going to say, which is that it's very important to have the right to audit those expenses, to be able to see the books and records, which you don't have the right to automatically if it's not actually added to the lease. So that's another thing that we always add to our leases, the right for at least once a year to be able to come in and as a tenant and see what those charges and how they're passed through to you. And again, it can impact a franchisee's bottom line.
Well, Nancy, you've been a wealth of information, and I'm so happy that you didn't lose electricity like so many in your area are losing.
I know. Thank goodness.
Well, appreciate you, my dear. Hope to see you at the IFPG retreat. We've got our live event January 4th through 6th, but then our virtual October 5th through 7th. So lots of fun virtual events coming up, by the way. Exactly.
Wonderful. Well, send me the information on it. I would love to.
Yeah, you're guaranteed. All right, gang. Thank you again for joining Franchising. Oh, I was going to say Franchising Strong Together, but the new title, FranchiseWire Live, with our friend Nancy Lanard from Lanard and Associates. Thanks again, Nancy.
Thank you, Red. This is fun.
My pleasure. Yes, it was. Thank you.